All right, welcome everybody. You have joined us for Working with Corporations, Partnerships, and LLCs, an introduction to the basic terms, red flags, and strategies that you need to know. I'm Jennifer Shepard, the sales manager for Chicago Title Fresno Madera. I do have a few of our people on the call with us as well. Linda Federico Johnson, Brad Fisher, Robin Albert, our newest sales exec, Lizette Pumarejo, and we have escrow officer Stevette Gambrill joining us. And then, of course, our lovely lead instructor, Loveneat Baines, who will introduce in just a minute. We always do a quick commercial for a couple of things we think will be of value to you. Oops, I don't know what happened to that. Well, I guess I'll be covering our agenda first. The documents that we need for verification with all the different entities, why the Secretary of State status is important in corporation and LLC transactions, who can sign as a buyer or seller, rules regarding Form 593 and Form 1099, the disbursement of funds, dealing with the deceased in a corporation, partnership, or LLC, other challenges to closing, and Q&A. Well, I guess my commercials are missing from this, so we'll just go straight into the presentation, and I may wrap up with a couple of commercials at the end. So Loveneat, take it away.
Thank you, Jen. So today, as Jennifer just went over, we're going to be talking about corporations, partnerships, LLCs. I'm going to throw in just a couple of notes about trusts and estates. So I'm trying to cover all things entities. So when you have a buyer or a seller who is coming into title or selling a property not under their individual name. So there are a variety of documents that we collect depending on the type of entity that it is that we're dealing with. So if there's a trust that we are dealing with, we collect the entire trust agreement to verify who the successor trustees are. If there is an estate that we're working with, we work with the probate attorney to collect the document called the letters of administration, which verify who the signer is for the estate. For corporations, there's bylaws, articles, there's statements of information for LLCs, there's partnership agreements for partnerships. So every different entity has their own set of documents that we will collect for. And when it comes to you as agents collecting these documents, a lot of the times agents like for us to take the lead on collecting the documents, which we are more than happy to do because we have a list of all the things that we may need. Sometimes people will collect them from the customer and just ask, can you give me everything you got? And then we can sort through it. A lot of our clients will like to do that, or they like to come into our office, they hand us the binder and we go through. We know what we're looking for. So those are it's much easier if you pass the responsibility on to us. But if you as an agent would like to help coordinate and facilitate that with your clients, we're more than happy to give you the information on what it is that we'll end up needing. So on to our next slide, which is why is the Secretary of State status so important for corporations and LLCs? So if you go onto, I'm going to use California as our example since we're in California. If you go into the California Secretary of State website, there is an area where you can search for business entities. So we go onto that site every single transaction that we have when we're dealing with a corporation or an LLC that is filed and registered with the state of California, and we make sure that they are in good standing. There's several statuses that a company can be under, one being suspended. And if your company is suspended or your client's company is suspended in the state, or with the state, excuse me, they aren't technically able to operate. So from a title standpoint, they aren't able to purchase or sell property if they are not in good standing. There are a variety of reasons why someone's LLC may fall into a not good standing status or suspended. I'm personally guilty. I forgot to file my statement of information for my LLC, and I got a notice saying that my company was not in good standing. So there's little things that end up happening if you don't file the filing fee at the appropriate time, or if you don't file your tax return at the appropriate time and submit it to the state. They can revoke your status from active to and good standing to suspended or inactive. So for the LLCs and corporations, the moment that we send over our corporation documents to our title department to review, at that time is when they check to see that the company is in good status. So the sooner that you get over the documents, or your clients get the documents over to us, the better. That way we can go in and we double check to make sure that they're in good standing. We also check to make sure that they're in good standing at the close of escrow. There have been instances where someone's company was in good standing at the beginning and then they weren't in good standing at the end when we went to close. And transactions can get delayed when that happens, because again, your company or your client's company has to be in good standing with the state in order to be able to proceed with closing on the transaction. There are some states that clients will register their companies with. A lot of people will do Nevada and Delaware are the two big ones that I see the most of. And in Delaware, you can't just go online and see that a company is in good standing just by going online. You have to actually request a certificate. I think it's $25 to request the certificate of good standing. So we have to request that the client pays for that, and it can take a couple of days to receive. So again, getting the documents over to us as soon as possible is the best practice. So some other guidelines for these types of transactions where we have corporations or LLCs that are involved. We can't have anything that is self-serving or self-dealing, where a company is selling to the principal that's involved in the company. So I can't purchase a piece of property from my own company. For example, Love Neat LLC can't sell to Love Neat Fans as an individual. Those aren't types of transactions that Chicago Title will handle. I can't speak for what another company may or may not do, but I know for us, that's just one of our underwriting guidelines, that we won't do any sort of conveyances to the individual partners or the managing members of the company. For foreign sellers, the same rules apply if the seller were an individual. They would also need to follow the guidelines that apply for whatever country that they're from. So the entities have to be filed in the state. I just recently saw this where there was a Nevada company and they do several Nevada LLC, and they do several transactions in the state of California, and they were also registered with the state of California. And I was able to very easily find them and figure out that they were also filed in the state of Nevada. So depending on where the company is operating, they also should technically file in that state as well. So if you have a client who is doing a lot of business in the state of California, even though if their company is originally from Nevada or Delaware or Florida, whatever state that they're from, they would also more than likely should also file their paperwork with the state of California as well. All of the signatures on the documents also require capacity. So when we list that someone is signing on behalf of an LLC, we also have to list their title. They're not just a signer, they are a managing member, they're president, they're CEO, they're the secretary. So there's always a capacity that is also listed with their signature. Now, I want to talk a little bit about drawing up a contract. So when you have a corporation or an LLC purchasing the property, excuse me, on the contract, you will list the buyer as the entity. So if you have, I'll use my LLC as an example. So my LLC is called the Beehive Salon LLC. The buyer on the contract will be listed as the Beehive Salon, and the signer will, and the initials of that will go all throughout the contract. They won't be the initials of the Beehive Salon. It'll be my initials because I'm the signer. The LLC can't sign for itself. There's always someone who's the managing member of an LLC that will sign the paperwork on behalf of the LLC. My LLC, there are several people that are involved. So we have resolutions that have been drawn up that say that I am authorized to sign all of the documents for any transaction that the LLC is involved in. If you have a client who has an LLC where there are several people mentioned, but only one person is going to be signing, we have templates for resolutions that we have provided to our clients in the event that only one person or two people are going to be signing. But all of the members of the LLC will sign that document to approve of who is going to be signing for the transaction. And I'll talk a little bit more about that in just a few minutes. But going back to the contract, when you have a entity that's purchasing, that entity will be listed as the buyer. Your signer will be the managing member of the LLC or the president of the corporation or the secretary, whoever is appointed to sign. And you will need to complete an RCSD form, the Representative Capacity Signature Disclosure Form. When you originally draw up the contract, there is an area in the new contract where you can complete that portion and it'll indicate who is signing on behalf of the entity. If not, you can also just supplement it and do the RCSD form where you will detail out the name of the company, who is signing, and what their title or what their capacity is. And that just helps tie everything together. It shows who's signing on behalf of the company, and it just makes it very clear what's going on. When you list the buyer as the individual, so if you were to list Love Meat Veins as the buyer, and you did the RCSD, it's technically not correct because I'm not really the buyer, I'm just the signer. I could have anybody signing for my LLC. And there are people out there that do that, where they have other people appointed to sign on behalf of their company, on behalf of their trust, the estate. They're just signers. If you list my name as the buyer, then we're checking my name for liens and judgments, where everything is going under my name. But that's not what it is that we're trying to achieve here. We want to make sure that there's a very clear indication of who the buyer is, and the buyer would be the company or the corporation, the LLC, whatever it is that I'm buying the property under. So it's very important when you're drawing the contract to make sure that you have the correct entity listed. And if you ever need help when you're going through and writing up these types of transactions, you're more than welcome to call us or email us and say, hey, is this the correct way to do it? I have lots of clients that will reach out to us before they write an addendum or write up a contract, just to double check to make sure that it's going to satisfy what we want, because I would rather everybody do it correctly the first time and ask the questions instead of doing it incorrectly and then having to go back and redo it or fix it with addendums. So just a good practice. And going on to our next slide, where we have corporations. So corporation documents, those typically include articles of incorporation and bylaws. Those are the two things that we like to collect, and any resolutions that confirm who has signing authority for the corporation. So like I was talking about a little bit ago, sometimes there are several people that are mentioned in the bylaws or the articles of incorporation that have the ability to be able to sign. And we like to have clarification of who is going to be signing. So we like to have a resolution prepared where all of the board members or the appropriate number of board members per the bylaws and the articles, have come together and agreed that the property is being purchased or sold, and who is going to be signing all of the real estate documents. And as long as we have that resolution signed by all of the appropriate members of the corporation, then we're okay to proceed with only having one signature or two signatures, depending on whatever it is that all parties agreed upon. So even if the bylaws and the articles of incorporation say one thing, meetings can be called and resolutions can be signed to amend those. Because we have, like recently I had a client who was going to be going out of the country, and normally he's the one who always signs all of the corporation documents and all of the escrow paperwork and the purchase agreement. But because he was going to be out of the country, he wasn't going to be available to sign the grant deed. He would have to go to a U.S. consulate. He didn't want to be bothered with that. So he had appointed someone else to sign on behalf of his company, someone who is not involved in the corporation at all. Our underwriting department came together and provided me with a document that we were able to provide to him to have signed and get notarized, so that we felt comfortable with having a third party sign for his corporation while he was not available to sign. So there are hiccups that we come along with that for example, like my customer who went out of the country, but as long as you communicate with us, there are ways for us to be able to come up with solutions so that we can work together and to make the transaction go as smoothly as possible. For limited liability companies, the main document that we look for is the operating agreement. Some people don't have an operating agreement, and this applies more to older LLCs, where I see if it's just a single member LLC, when there's just one person who's the managing member, and they won't have an operating agreement. We do have a statement that they can sign confirming that they're the only member of their LLC. So then we don't require an operating agreement. But now, based on how people set up their LLCs, usually it's not a difficult task to request an operating agreement. So that's the main document that we require. And again, we go through that operating agreement and we look to see who the managing members are. So if you have 5 managing members, we're more than likely going to require the 5 signatures, unless you provide us with a resolution or request for us to help you with writing the resolution to confirm who the signer is going to be for the transaction. For partnerships, there's a couple different types of partnerships that can exist. There are just a general partnership where all of the partners would be the signers for the transaction. Again, unless there's a separate partnership agreement, which gives details on who is going to be signing. Depending on how you hold title, I have a property that I hold title with individually with a couple of people. We have a partnership, but because each of us is in title individually, we would each have to sign off on the property. Even though I have a separate partnership agreement that says one person can sign and conduct business for the partnership, because all of our names are in title, all of the people would need to sign. This is a similar thing that applies for trusts, where if you have multiple trustees in title as trustee of a trust, and the trust agreement says that only one person needs to sign, we still have to have all parties who are in title sign off on the grant deed and on the purchase agreement and our escrow papers, because they're entitled and it's of record with the county. The county can come back to us and say, well, what happened to this person? Why didn't they sign off? And their interests would technically be left behind. So that's why anybody who is of record on a grant deed has to somehow, their interest has to be addressed, be it through an affidavit of death or a change of trustee affidavit or a resignation that's been recorded. There's a variety of ways to remove people from title, but if you're in title, just because you have some sort of agreement that says only one person needs to sign, you still have to either sign off or your interest has to be dealt with in another manner. For limited partnerships, there's an agreement where there's the limited partners and then there's general partners. Limited partners are usually the people who are doing the financing of it. The general partners are the people who manage the day-to-day activities of the partnership. So we would look within the partnership agreement to see who the generals are and who the limited are. The limited partners typically are not the signers. It's the general partners who are the signers. For the tax reporting requirements of the different entities, this is a California State Tax Withholding Form 593. For anyone who does a lot of flips or sells a lot of property, it's a very common form. It gets filled out and submitted to the Franchise Tax Board on every single transaction. So if you're an individual, there are essentially two options for you. You're either taking a loss or zero gain on the property, or the home was your primary residence. And then you would be exempt from having to pay anything to the Franchise Tax Board. For corporations, you are exempt. Item number 6 would be a box that you could mark, and the same goes for limited liability companies. So, and for partnerships as well, you're also exempt from having to pay to the Franchise Tax Board. Later on though, when you go to file your taxes, I know everybody probably hates those trips to the CPA when they have to report all of the income that they made from selling the property. So, but during the transaction, you would be exempt from having to pay anything to the Franchise Tax Board. And then the following slide, shows the rest of this form. Whenever you have an individual selling and they mark that it's a loss or zero gain, the second page of the form does have to be completed. It's the computation. We do not police the form. We ask for the customer to complete it or take it to their CPA, or they can complete it themselves. We don't do any double checking of math. We just look to make sure that there's something written there. And as long as there's something there, then the state will accept the form from us. And they will do the double checking. If there's anything that needs to be paid, or if it's not acceptable, then they will contact the customer and deal with it after the fact. So some red flags that we look for whenever we are dealing with corporations, any type of changes in their filing status. So if there's been a person that's been added or removed based on what has been uploaded to the Secretary of State's website, we also ask for documentation to support that. So if you have a partner that has been removed from a partnership agreement, or a managing member that's been removed from the LLC, we can see that on the Secretary of State's website based on the statement of information that gets filed. But then we also will request further documentation showing the removal or the resignation of that person. When there are people who have passed away within a partnership or an LLC, we have to fall back on what the existing agreement states to happen when it comes to those types of things. So I recently had a transaction where there were several partners and every partner was deceased, but the wives of the partners went through probate and they had documentation to show that they could sign on behalf of their husband's estates. So we were able to use that documentation to be able to complete our transaction, because they went through probate and they collected the appropriate documentation to be able to sign on behalf of their husband's estates, excuse me. I personally have an LLC, and the managing member of my LLC is my trust. That way, the trust never dies. So if I were to pass away, then my trust states who can sign on behalf of my trust. So there's always a signer. Talk to your attorneys. That's the best advice that I can give when it comes to each individual situation. There's ways that you can avoid probate and, having to put your families through the process of figuring out how to sell all the properties that you may own or that your investor owns. So planning ahead is the best practice. And again, talking to an attorney, setting up trusts and wills, power of attorney, all these things, it just really helps with getting through the process of selling when you're dealing with an entity. Again, any transactions that involve self-dealing or self-serving, where you are transferring, when you're a principal involved in the company, those are things that we look for. So when the client send over their articles of incorporation, the bylaws, the operating agreement, we do read through that, and we have to make sure that the same parties that are selling are not also involved on the purchase side of it. And then any variations in name changes. So if you have a company and you changed the name to add a number, or made it plural, or there was a middle name added or anything like that, those are things that we look for, because those minor details are actually a big deal for us. Where there may be a company out there where their company name is plural and your company name is singular, and the plural company name is suspended, but your company is not. So it's important to pay attention to those types of things for us and for the client. And if there's ever any errors when it comes to them coming to title, I mean, we're all human. There could be a typo, things happen. When those types of things happen, as long as you have the supporting documentation to show that your company is actually the company that you're stating it is. So like, for example, if your company is plural and there's a company out there that's singular that is suspended, as long as we have the documentation to show that your company is actually this other one, we can always go back and fix anything title wise, or we can have the previous title company go back and make corrections if there was an error that was made.
Lovenita, I have a quick question for you.
Sure.
We've had a couple of transactions where it appears that people made a slight change to the name of the company, or actually started a new company, I should say, with a slightly different name, possibly to avoid things attaching to the property that were attached to the old partnership or LLC. How do we normally handle that?
So I haven't personally had to deal with anything like that, but I would, from my experience, I would say that if there is a change and it's clear what is happening. So if I held title, for example, to a property under Love LLC, and then Love LLC ends up having state tax liens filed against it, and then I decide, okay, I'm going to actually start Love 2 LLC, and I'm going to transfer all my properties there. When that happens, when there's this transfer and there's uninsured deeds and there's no transfer tax, no title insurance involved, we still go back and we look at what happened. Why did Love LLC transfer to Love 2 LLC? And we would search at that time of what liens were of record, liens and judgments, or we can look at the Secretary of State's website and see filing changes, and we can ask the customer the questions. So when that happens, we still have to deal with any liens that are of record against that first LLC or corporation or whatever it may be. When there are new companies that are set up, particularly with LLCs, and more so when they're single member managed. So if it were my LLC, Love LLC, and Love Neat Bains is the only managing member, and it's a newly established LLC, we would also run my name for liens and judgments. And it's not that to say that I'm avoiding the liens and judgments, but that's a lot of the times why some people will set up entities, is to avoid having to deal with any personal liens. That's why it's really important when drawing up the contract that it's drawn up correctly the first time, because if you list the buyer as Love Neat Bains and Love Neat Bains has state tax liens against your federal tax liens or personal property tax, whatever it is, those will end up coming up on the title report because we're checking for liens. If you actually list the company name, then we're running the company's name, not the actual signer's name. The signer is just the signer. They are acting for the company. And again, you could have a completely different third party acting on behalf of your company. Their name is not ever checked for liens and judgments. It's more so with the single member LLCs, where we will go back and check to see how long they've been in existence for. And then based on that information is when we would also check for liens and judgments against their name. From there, it's an underwriting call. If it looks as though someone may be trying to avoid their liens, we have that conversation at that time. Does that answer your question, Jen?
Yes.
Okay. All right, last one here is assignments. So this is something that comes up a lot with our investor clients, and I just wanted to go over it a little bit here. So we have a lot of transactions where we are dealing with for sale by owner contracts, where it's a contract that the investor may have came up with on their own or with their attorney or off of LegalZoom, whatever it is that they use. So we have those types of contracts, and then we have our car contracts. The car contract actually does have a form for assignments, and a lot of people will use this form to add a buyer's spouse onto title. So when we're going through the transaction and they realize that they do actually want to include their spouse on title, they can use the form AOAA. It's the Assignment of Agreement Addendum. And you can do a partial assignment or a full assignment to someone else. So if in the middle of the transaction, if I decide I can't purchase this property, I want to assign it over to my brother who can, that form can be used in order to assign the entire agreement over to another party. With the car contract, the buyer, the seller, and the assignee and assignor have to sign the form, the AOAA form. When it comes to for sale by owner contracts, the contract can be assigned over to another party, but that assignment agreement doesn't necessarily have to be signed by the seller. The assignor and the assignee sign the agreement, and then they usually also indicate assignment fees within that agreement. And we can utilize that to change who the buyer is. Through our escrow papers, though, because we have a for sale by owner contract, we prepare escrow instructions. And within our escrow instructions, we will prepare a document that confirms and discloses to the seller that the contract has been assigned. So when these types of agreements are drawn, usually the contract will be written up as the company that's purchasing it and or assignee, so that they have the ability to be able to assign over the contract. So again, an escrow instruction is prepared, and it does disclose to the seller that the contract is being assigned over. It does not disclose any amounts, and that's not any information that we would provide to a seller when it comes to agreements that have been assigned. Again, this goes back a lot on people who are investors and flipping property. Usually they are the ones that prepare these types of agreements. Again, we don't go back and tell the sellers any of the information that's listed on the assignment agreement between the assignor and the assignee when it comes to any fees that are being paid, or like a referral fee or an assignment fee amongst those two parties. But the seller is disclosed the information that the contract has been assigned and that there's a new buyer. As for assignment fees, I recently had a lot of these where on the assignment agreement, people were listing other parties to also pay if there were multiple people involved in coming together with the end buyer. We can only pay an assignment fee to the original buyer and the party that then becomes the assignor. We can't add on any other third parties to be paid through the transaction. And when we do pay them the fee, their assignment fee, we also have them sign a form and we issue a 1099-M to them. It's a 1099 miscellaneous form for miscellaneous income that was provided to them through our transaction. During escrow, we also provide 1099s to LLCs, but not to corporations. I forgot to mention that when we were talking about the 593 form. So corporations are exempt from 1099s, but LLCs and partnerships are not. So at the end of the year, or at the beginning of the following year, your clients would end up receiving a 1099 form that shows the gross sales price of the property. So they would need to take their 1099 along with their final statement, and their CPAs can help with reporting the income accordingly. And that's all I have for you guys today. Are there any questions?
At this point, if you would like to unmute and ask Loveneet a question, you're welcome to do so. Wow, Love, I guess you covered it all. Nobody's.
If anyone does have any questions after the fact, you are more than welcome to contact me at any time. You can give me a call, send me an email, shoot me a text, whatever works best for you. Find me on social media. You see my shoe pictures of the Love Neat Challenge. But again, any questions at all, feel free to reach out to us at any time.
Neat. I do have a question. Shannon Marr with Guarantee Real Estate.
Hey there.
Hey, I don't think I saw it, but at any point in this process does a need for a statement of information ever come about?
So there are, I guess I should have clarified this earlier. I apologize. So there's two types of statements of information. When we're talking about companies and they're filing paperwork with the Secretary of State, there's a document called a statement of information. And on that statement of information, it details out, for example, for an LLC, it details out who the managing members are, who their agent of service is. So in the event of someone getting served, if they're going through a lawsuit, who is to be served, that's the agent of process. Or the agent of service, excuse me. When it comes to statements of information for us as a title company, where we are gathering a statement of information and collecting information to clear a person's name of any liens or judgments. So an SI for title company purposes is where we collect date of birth, social, phone numbers, addresses, work history, spousal information, previous marriage information, your children's information, names and date of birth to check for child support liens. That is a different statement of information. Gotcha. When it comes to the company, though, and like for a corporation, for example, would we ask for a statement of information on the signer for the company? No, we would not. With an LLC is the only time really, and with partnerships is the only time really where we will check their individual names if the company or the partnership was just recently formed, because sometimes it could be a sign of them potentially trying to avoid any liens. And I've actually had that happen before, where we had a client who had 4 different escrows opened in our office, and one of the escrow officers found a lien, and then I found liens, and then the other, eventually we were in the copy room talking about it, and then all of us realized that we all had an escrow for this person, and he ended up telling one of us that he was setting up a company to try to avoid the liens, and underwriting said, no, you can't do that. So for a statement of information to be ran on an individual that's signing for a company, it usually only happens when it comes to the partnerships and the LLCs.
Partnerships and LLCs. Okay, good. A second question I have is, the board resolution giving the signer the ability to sign on the company or entity's behalf. Does that always have to be voted on by that board and then signed specifically or signed personally by that secretary who was at that meeting taking those minutes?
It depends. So again, we fall back on whatever the original agreement states. So if you have an operating agreement, for example, if we're dealing with an LLC, okay, within that operating agreement, it will indicate who is supposed to take meeting minutes, who is responsible for signing resolutions. If there is no indication that there's anyone that's been appointed with that duty, then we would fall back on just having all of the managing members sign and approve the resolution. And
Okay.
that's something that we actually do quite a bit, where we have multiple people that are involved in an entity. And this form, for us, at least, we're okay with digital signatures on it. A lot of the times the people are located in various areas. So we'll help with preparing the form, and then we can even send it out for signature. So we try to help make the process as easy as possible.
I see.
So we'll send over the form, and I'll even leave the dates blank. That way, if they come together in a room together and have a meeting, then they can list the appropriate dates on the form. And if there's any additional information that they want to fill in on the form, they can for their purposes.
Okay. Okay. And then last question is, I've seen this happen a lot too, but when someone from an entity presents us with that board resolution, does it have to be specific to that particular transaction, including the buyer and property? Because I've seen some try and pass off, maybe a previous buyer who was under contract before that fell apart, and then, or maybe, a previous date, because they just don't want to go through the trouble of getting, that secretary's signature. So do you see that a lot? And then does that have to be updated for that particular buyer and or specific transaction?
So there's some entities that our company works with regularly where we have allowed for them to alter the resolution to where it states for all transactions. So we don't have to constantly go back over and over again to have a resolution done for every single transaction.
Oh,
Now,
wow.
I also have other clients where there's a different person that signs every single time. So we help them and we ask like, okay, so who's going to sign for this one? And then we won't list who the buyer is in the transaction. We just list for the sale of the property, and that's it. We don't give any further information like what the sales price is.
Oh,
That
cool.
way, we can take that resolution and use it for further transactions. We
Okay.
want to try to make it as easy as possible because no one wants to be inconvenienced and have to do these resolutions
Yeah.
over and over again.
Yeah.
Now, if we're dealing with something else, like, for example, right now I have a transaction with a nonprofit and they have board meetings weekly. And if there were a couple of changes that we had to do during the transaction, and we had to have the board sign something every single time. So the secretary was working with me and providing me with the meeting minutes and signing off on the changes that were happening in the transaction. And so it just kind of depends on what the situation is. But for the most part, we want just one resolution. Sometimes though, if it comes down to it, like if there's multiple people that are involved and there's changes, then we'll ask for another resolution, but we'll help with preparing it.
Gotcha. That's actually a really good idea. I was thinking about actually implementing that because I mean, I know it's a hassle every time to have to change and edit it, but maybe a generic resolution probably work best. That's a great idea. Maybe do that in the future cases if I can get them to agree to that.
Perfect.
Okay, great. Thanks so much.
You're welcome, Shannon. Anyone else?
Nate, this is Gabriel Bloom. Just want to say you are a treasure trove of information, and thank you. That was a solid presentation. Really appreciate it.
Thank you, Gabe. Appreciate you.
Hey, I'm impressed that Gabe's on.
As always, we have recorded this presentation, so it takes a little bit of time for it to download and then be available for me to load onto our YouTube channel. And then I'll send out an email to everybody letting you know that the class is available. You can check out our YouTube channel, Chicago Title Fresno, for an archive of every class that we do. So if you accidentally deleted a recording or something, they are all there waiting for you. Or if you come up with a situation that's new for you and want to see if we have a video on it, you're always welcome to watch those. And you can even subscribe to our channel so that you're alerted when new videos are posting. In 2023, we hope to also start doing some shorts on that channel with just one topic at a time that we're covering that will be a searchable library for you. So keep an eye out for that. Thank you so much for taking time out of your Friday and joining us for this class. Thank you, Love, for a great presentation. We are all here for you. If you need anything at all, don't hesitate to reach out to Love or our team. So thank you so much and have a great weekend. We'll conclude the class.